Ryan from New Jersey, welcome to the program, Ryan.
I just wanted to bring up another topic. I know how you were talking about the absurdity of the Supreme Court with the Civil Rights Act section before with your first interview.
Yeah.
If you read the New York Times last morning, they also had a rejection of the legal challenge to surveillance of the 2008 law that was put in place.
Yes, actually, I have that right here. Go ahead.
I didn't realize you were going to get into it.
Well, I have it. I was going to actually save it for tomorrow, probably. Clapper versus Amnesty International, I believe. It was a 5-4 holding, and it essentially said that you cannot challenge secret wiretapping because of its nature of being secret, and therefore, yes. I mean that we've heard that on lower level courts. I'll get into it over the coming days. But yes, it's just another example of how effed up this stuff is.
Yeah, I mean, going forward, the paper says that the decision, the 5-4 decision where all the conservatives came together and, rejected the challenge, that basically this means that going forward, the Supreme Court will never rule on the constitutionality of that law itself.
How can it? It's secret.
Yeah. I mean, the argument by the majority is that basically you can't bring forward a case where you're saying that your civil liberties are at risk,
right,
but you can't prove it because the government doesn't give out the information to you.
Right. You don't have standing
give it out.
To bring a case to any court. You need to show the court that you have somehow been harmed by this. And we saw this actually with the NDAA case as well, that Hedges and others were involved in. And essentially, you need to prove that you as an individual or you as a class of people have been harmed by this case, by this law. This is also analogous to what happened to Anwar al-Awlaki's father. The father could not bring the case to say, hey, I want to enjoin the U.S. government from killing my son. And they said, well, you're not the one who's going to be killed, so you can't bring it on his behalf. And so if you have to prove that you are somehow being harmed by this law. But if it's secret, you can't prove that. Now, there was one case in the NSA on the West Coast on this wiretapping where the government accidentally forwarded records to the defendant that they had been spied upon. And therefore, they had record that they had been spied upon and could bring that up and provide them standing. And so the issue is how do you prove that you are being subject to illegal spying or wiretapping in this case, if it is secret and you can't get the government to show whether or not that you've been spied upon, you only suspect it. This is the catch-22. And it essentially says that we can never, if you're the subject of a secret warrantless wiretapping program, you need to prove first that you're allowed to complain about it, that you're being wiretapped. And so that means that you somehow need proof of the existence of this program, which is secret. So it's a classic catch-22. But I'll go into it more in depth over the coming days.
Yeah, I just wanted to say, though, I'm not surprised that, in particular, that Antonin Scalia, and
of course not.
It's obvious that he would be a part of the majority.
Of course not.
But also you had the, I like to call the silent assassin, Clarence Thomas also, the pinnacle of Supreme Court justice himself, also a part of this majority ruling. So
I mean, look,
always fun to see him along for the ride.
I hope rulings like this and other rulings speak to, and I appreciate the phone call. I'm going to let you go. Ryan, thanks. Speak to the importance of the Supreme Court. All those people who are poo-pooing a vote for Obama for the sake of the Supreme Court, this is another example of it. And as much as people like Kagan have been criticized for deferring to the state's power, this is an example of it coming down to 5-4 again. And I don't know if President Obama will have an opportunity to replace one of those people in the 5. I don't know that he'll have an opportunity to replace one of the people in the four. It's likely he will. And he will with a justice who will be there for 30 years. Whereas you've got a couple of justices in that 5 voting block who won't be there for 30 years, who will be there for another 5 or 10 or 3. And there will be an opportunity to replace them and perhaps, if not reverse some of these rulings, mitigate the trend in some fashion. The left simply has to pay more attention to this. And then it would also create more pressure on who the president will pick. I mean, that's just the reality of it. And it's, I mean, if the election of 2000 wasn't enough, I mean, give me a break.